Good afternoon and welcome to this LexisNexis webinar on changes to designs law and practice after the Intellectual Property Act 2014. My name is Michael Carter from Wragge, Lawrence Graham & Co, and I'm here with my colleague Alice Stagg, who is also a Senior Associate at Wragge, Lawrence Graham & Co.
Hi everybody. Michael and I are both experienced in designs law, Michael particularly in the automotive sector, and for me more in the fashion sector. First
of all, first ownership of designs has changed, whereas previously, and this particularly relates to people who commission third parties to create designs for them, and such parties previously, where a commission was involved, it was the person who commissioned the design who would own the design right. And that is UK registered and unregistered design right. That is no longer the case. Following the Act in 2014, first ownership of design rights vests in the designer unless the contract provides otherwise.
So would that be, for example, where a company engages a freelancer?
Yeah, exactly. So you'll find this is common in industries such as the automotive industry, where you will have designers who will be employed, but you will also have designers who are freelance designers on a temporary contract who will help with the design process and will be on a commission basis. And this will particularly affect those sorts of industries and those commission relationships. So following the 2014 Act, it is now the designer who is the first owner of any design right in a design which is not created in the course of employment. So it's important to make clear this does not affect employed designers, but only those who are creating designs pursuant to a commission. This change brings UK design law into line with the European design law, where it has always been the case that it is the designer who is the first owner of the design. That's also the case in relation to UK copyright. So in many respects, this has simplified the law in the UK and made it consistent across both EU and UK rights. It's also important to note that this change is not retrospective. It does not apply to designs created before the 1st of October 2014, nor does it affect contractual agreements which were already in place at that date, where the design was created after that date. However, I would caution against relying on long-term contractual arrangements at preserving the status quo, and to review your current contractual arrangements with third-party designers to ensure that they have the relevant assignment clauses in them so that the design rights have been assigned to you and no longer vest with the designer.
So looking at section 213 of the CDPA, and this is where the definition for UK unregistered design right is set out. And on the slide you can see what's showing in red line. That's the change which has been made as a consequence of the enactment of the IP Act 2014. So now a UK unregistered design is the design of the shape or configuration, whether internal or external, of the whole or part of an article, whereas previously it was any aspect of the shape or configuration of the whole or part of an article. And the explanatory notes to the Act say at paragraph 10, in the second sentence, really that the intention here was to reduce the tendency to overstate the breadth of unregistered design right and the uncertainty that this creates, particularly in relation to actions before the courts. But actually it seems likely that in many cases the change isn't going to make much difference. And that's because section 213 still covers the design of the shape or configuration of the whole or part of an article. It's quite difficult to see what the difference is between part of an article or any aspect of the shape of the part of an article. And in a couple of cases which have come before the courts, in fact the only cases so far where this has been considered, it hasn't made any difference. The two cases are DKH Retail and H Young, and that was in relation to a gilet design which was branded with the Superdry retailer branding. And the second case was Whitby Specialist Vehicles and Yorkshire Specialist Vehicles, and that was in relation to an ice cream van design. And for example, in the second case, the part of an article included breakdown of designs, parts of the van as small as the bumper.
And this, I think, probably relates to a piece which, a question and answer piece, which I think you did in advance of this webinar, which asks whether
I think it's on the LexisNexis website as well.
Which asks whether design rights is still still the poor relation effectively in relation to the IP family, and should it be seen as such, or is it a very valuable right still?
Well, I think that in certain sectors it's not ever really been the poor relation anyway. So in the fashion sector it's always been a major right that's been enforced and relied on, because perhaps there is less patent protection in that area, and I think that's probably true of quite a few other sectors as well. The creative industries are a very important part of the economy, UK economy. I think hopefully that it will encourage people to enforce their rights, to register more rights as well, which would be excellent, and particularly things like the design opinion service, which we were just talking about. Also perhaps the UK's accession to the Hague Agreement, which hopefully has made it easier to enforce rights, means that the registered rights are more freely available to smaller companies. But at the same time, unregistered protection is still there and does offer quite substantive help when people are infringing anyway. Don't know if you'd think the same from your experience.
No, I do, and I think certainly I've seen over the last couple of years an increase in design right cases, and part of that may be the success of unregistered design right, and I think that will probably continue following the Act. But also the Intellectual Property Enterprise Court, I think, has had an impact on allowing infringers to bring design rights claims with a cost limit and a cost cap to that. And we have been involved in a couple of design right cases now before the IPEC and its predecessor, the Patents County Court. And it is a very good forum for design disputes, because it does control the amount of evidence which is involved. So
it does allow some evidence to be introduced.
It allows some evidence to be introduced, but it keeps it proportionate, which in design cases is important to control costs. So from my perspective, I really don't see design right as a poor relation in the IP family of rights. It's something which is used extensively, and hopefully we will see increased instances of registered rights as well as these changes flow through.